Judges Okolie and case concerning immunities of a diplomatic agent, Majan versus the United Republic of Aristan.
Be seated. The court is now in session. Are the parties ready to present their argument? The applicant, Majan. May proceed.
Mr. President, Your Excellencies, my name is Lisa Johnson. My co-agents are Catherine McHenry and Greg Taraposky. We represent the state of Majan, the applicant in these proceedings. I would like to draw the court's attention at the outset to the key facts in this dispute as they relate to the issue of diplomatic immunity. Aristan's ambassador to Majan was involved in a drug trafficking operation through which drugs were smuggled into Majan by diplomatic pouch. He was caught when, after a drug transaction went sour, he attempted to run down his drug contact, a Majani national, and in the process killed 2 innocent bystanders. The applicant respectfully requests that this court not permit the ambassador's actions to go unpunished. Mr. President, Your Excellencies, there are 2 main issues before the court in the present dispute. The first issue is whether Majan may criminally prosecute former Ambassador Quintero consistently with its obligations under the Vienna Convention on Diplomatic Relations. The second issue is whether the assets assigned to Majan on an administered deposit account with the IMU are immune from seizure. I will be dealing with the issue of former Ambassador Quintero's diplomatic immunity, and then my co-agent, Ms. McHenry, will be addressing the issue of the immunity of the assets of the IMU. There is one further issue which I would like to mention briefly at the outset, and that is the question of provisional measures. The respondent has requested that this court grant provisional measures providing for Ambassador Quintero's release and the dismissal of all charges against him. The applicant respectfully requests that this court deny these provisional measures on the grounds that 1, they are designed to obtain an interim judgment on the merits of this case, and 2, the provisional release of Ambassador Quintero could irreparably harm Majan's interests in this dispute if the ambassador were to flee our jurisdiction to a territory with which we have no extradition treaty. However, Majan is primarily interested in obtaining justice and restoring friendly relations with the government of Aristan. And to that end, the applicant concedes that this may indeed be an appropriate case for an indication of provisional measures. However, if the court decides that it is such a case, the applicant would suggest that in this case, a stay of the criminal proceedings against Ambassador Quintero would suffice to protect Aristan's interests in this situation. In the further alternative, if the court should grant the measures requested by the respondent, the applicant would respectfully request that this court include measures designed to ensure the return of Ambassador Quintero to our jurisdiction if the court should decide in our favor on the issue of diplomatic immunity. On the issue of diplomatic immunity, the problem before this court relates to the duration of diplomatic immunity. Both parties agree that diplomats are absolutely immune from the criminal jurisdiction of the receiving state during their diplomatic posting in that state. The applicant is in complete agreement with this court's comments in the United States diplomatic and consular staff in Tehran case. However, the U.S. and Iran case did not address the issue that is before the court in the present situation. In the present case, Ambassador Quintero is no longer the accredited diplomat in Majan. And for this reason, the applicant submits that he is now subject to criminal prosecution for the acts in question.
Counsel, is it your contention that the U.S. v. Iran case is relevant in this case?
The case of the U.S. and Iran is relevant only insofar as it sets out the general principles in diplomatic immunity, in that all of the law pertaining to diplomatic immunity is contained in the Vienna Convention on Diplomatic Relations. All of the remedies available to a state that believes that there have been abuses of diplomatic immunity are contained in the Vienna Convention, and the applicant agrees with the respondent on this issue, but the applicant would contend that the prosecution of a former diplomat for non-official acts is a remedy available to it under that convention.
Counsel, I note at page 2 of your memorial that you refer to the Vienna Convention on the law on treaties as being open for signature on the 22nd of May, 1969. Are you correct on that date? That's page 2 of your memorial.
I believe it was adopted on May 22nd, 1969, open for signature on the 23rd of May. Now, if...
So the correct date should have been 23rd, but not 22nd, in terms of the time of it was open for signature.
That would be correct, Your Excellency.
Do you agree with that?
Yes.
Okay. And furthermore, on that same page, you did make reference to Vienna Convention on Diplomatic Relations.
That's
what
correct.
Year was that?
That was adopted in 1964. Now, if Your Excellency is concerned with the applicability of the Vienna Convention on the Law of Treaties to the interpretation of the convention with which we are now concerned, the applicant would suggest that the Vienna Convention on the Law of Treaties codified the rules of customary international law regarding the interpretation of treaties and conventions. And in that sense, it is generally applicable to interpreting this convention, although, strictly speaking, the court is not bound to apply the rules set down in the Vienna Convention on the Law of Treaties to this case.
Which year was it that you referred to the conventions on diplomatic relations?
That convention, I believe, was adopted in 1961.
And you said that that was exhaustive of all rules of international law on the subject?
In the U.S. and Iran case, the court held that the laws of diplomatic immunity were a self-contained regime, although the Vienna Convention specifies that if a particular problem is not covered in the convention, that the rules of customary international law will prevail. But the court in general viewed that the remedies available to states were covered in the convention, and that a country could not step outside of this convention to seek redress for abuses of diplomatic immunity.
What about the preambular paragraph of the convention, which says that affirming that the rules of customary international law should continue to govern questions not expressly regulated by the provisions of the present convention, i.e. Vienna Convention in 1961?
Yes, that's correct, Mr. President. The applicant would contend that the rules of customary international law, in fact, support the applicant's position, and in addition, that this particular situation is a situation expressly governed by the Vienna Convention on Diplomatic Relations.
When you say that this issue is expressly governed, are you referring to paragraph 2 of Article 39?
That's correct, Your
And
Excellency.
what does that paragraph provide, and what are the issues before the court with respect to its interpretation?
Article 39, paragraph 2 states that when the functions of a person enjoying privileges and immunities have come to an end, such privileges and immunities shall normally cease at the moment when he leaves the country or an expiry of a reasonable period in which to do so, but shall subsist until that time in the case of armed conflict. However, with respect to acts performed by such person in the exercise of his functions as a member of the mission, immunity shall continue to subsist. Now, this last sentence gets to the heart of the issue that's before the court in the present situation. It provides that even after a diplomat leaves the territory of the receiving state, his immunity with regard to these acts, the acts committed in the exercise of his functions as a member of the mission, will continue to subsist. Now, the necessary implication is that immunity with regard to acts not committed in the exercise of his functions as a member of the mission will not subsist after he has left the territory of the receiving state.
And what is the basis for that interpretation? Is that related to your reading of this provision? Is there state practice that would support the position that you're arguing?
The applicant would suggest that the ordinary meaning indicates this interpretation, as does the preparatory work of the convention. And in addition, there is state practice in the application of the convention to support this view. And in regard to state practice, the applicant would draw the court's attention to the case of Empson versus Smith, in which the English Court of Appeal applied the Diplomatic Privileges Act of 1964. Now, that act implemented this convention into the law of the United Kingdom.
Counsel, how do you understand Article 38 of the Statute of the International Court of Justice? What is the understanding of the statute, Article 38 of the Statute of the ICJ?
I think the question is being asked.
38, Article 38 of the Statute
Yes.
of the International Court of Justice.
Now,
what is the understanding?
What is the point of your reference to a British case at this point?
According to Article 31 of the Vienna Convention on the Law of Treaties, it says that in interpreting the context of a convention, in interpreting the convention, you look at context, and in doing so, the court shall take into account subsequent state practice in the application of a convention in order to establish the intentions of the parties regarding its interpretation. Now, this was a situation in which the English Court of Appeal applied the Vienna Convention, and thus it's indicative of what the views of England were regarding the proper interpretation to be given to this convention.
Counsel, I'm interested on the sources of international law under Article 38 of the Statute of the International Court of Justice. Would you tell us exactly how you understand that very particular article? How do you understand it?
In this situation, the applicant is asking the court to apply the rules of the conventional law in this situation. The applicant is suggesting that this situation is completely governed by the convention, but that the court must interpret this convention, and in doing so, the court must look at state practice applying the convention in order to see what the party's intentions were for its interpretation. Thus, the applicant is asking the court not to apply the decisions of cases of municipal courts, but rather to interpret the convention and try and determine what it is that the convention was designed to do and how it was meant to be interpreted.
In other words, you're asking this court to decide this case on the basis of customary international law as opposed to treaty law. Is that what you're saying?
Not at all, Your Excellency. I am suggesting that we're not looking at subsequent state practice as evidence of customary international law, but merely as evidence of what the parties' intentions were regarding the improper interpretation of the convention. And therefore, we can look at comments of various municipal courts, even where they were addressing themselves perhaps more broadly than the situation required. In addition, we can look at the comments of various governments, for instance, the Department of State of the United States, and thus we can see what the intentions were of the various states regarding the interpretation that they wanted to be given to this convention.
Agent, one question. In your view, do you consider the provision of Article 39, paragraph 2, to be declaratory of existing customary rules of international law, or do you consider that to be progressive development?
The applicant would suggest that it was not progressive development. The applicant concedes that while there may be no cases precisely where a former ambassador has actually been prosecuted by a receiving state, this is not an indication of the fact that there would be, say, a rule of customary international law precluding a receiving state from prosecuting a former ambassador. In fact, there is a presumption against immunity that exists. There is a basic fundamental principle of the territorial sovereignty of states. And if the respondent wishes to assert a norm of customary international law that would suggest that Majan is precluded from asserting its jurisdiction, then it must show the necessary opinio juri. It must show that states have refrained from prosecuting former ambassadors out of a sense of legal obligation. Now, the applicant would suggest that given the cases and the comments of various State departments, that in fact, the receiving states view themselves as having the ability to prosecute former ambassadors and diplomats, even though in the circumstances of a given case, they may decide for other reasons, whatever they may be, not to exercise these rights. The rights nonetheless exist. Now, further on this question of state practice, there are a number of other cases. There is the example of the diplomatic immunity from suit case, which was a criminal case where the court held that although the action could not proceed at the time in question because the defendant was entitled to diplomatic immunity, once his diplomatic status had terminated, he would be subject to prosecution for the acts in question. Now, more recently, we have the U.S. preparations to prosecute Ambassador Absanito of Papua New Guinea on charges arising out of a motor vehicle accident. And more recently than that, we have the case of United States versus Guinand, in which a district court of the District of Columbia denied the defendant's motion to dismiss the case on grounds of diplomatic immunity. Now, in that case, the defendant was a member of the administrative and technical staff of the Peruvian mission. I should point out, however, that under Article 37 of the Vienna Convention on Diplomatic Relations, members of the administrative and technical staff of a mission are accorded the identical immunity from criminal jurisdiction as any other diplomat, as an ambassador. The only difference...
Identical immunity?
They are granted, they have much narrower immunity from civil jurisdiction, but their immunity from criminal jurisdiction is the same. Thus, the applicant would submit that this is a case of state practice where the courts of the United States have expressly declared that they feel they are entitled to prosecute someone who was entitled to diplomatic immunity once their status is terminated.
Counsel, the case you just referred to, the Papua New Guinea ambassador's case, was the ambassador actually tried in the United States? Was it?
Your Excellency, he was not. However, the applicant would contend...
Then what is the relevance of that case to your situation?
Because in that case, the United States showed its view that it felt it had the right, the legal right, under the Vienna Convention, to prosecute the ambassador for these acts. Now, the fact that they may have chosen not to do so, perhaps the two governments reached a settlement, there was compensation for the victims, and they may have decided, in order to maintain friendly relations, that in this case, the compensation was adequate and they would not prosecute. However, they indicated their view that they felt they had the legal right to prosecute the ambassador for the acts in question.
What was the reaction of Papua New Guinea?
Papua New Guinea asserted, as does the respondent, that this was a violation of the obligations under the Vienna Convention on Diplomatic Relations. However, the United States took issue with that and asserted that it was entitled to exercise its jurisdiction due to Article 39 of the convention with which we're dealing with here.
What was the position of the Dean of the Diplomatic Corps?
Excuse me?
The Dean of the Diplomatic Corps in Washington, D.C. Did he take any position in that case?
I do not recall it, Mr. President.
Counsel, may I call your attention to page 4 of your memorial. Here, you cited a rejected opinion in support of, look at paragraph 2 of page 4, and tell me whether you think that statement there is correct. You're talking about Article 39.2 is supported by the International Law Commission's rejection. And then, of course, in your footnote 11, I want you to look at it and tell me whether you think it's correct, that footnote 11, number 11.
Yes.
At page 4.
Yes, Your
Is it correct?
I believe it is, Your Excellency.
So the case here, you cited 1957, and then at footnote 12, you cited 1958. Do you think you are correct there again, on the footnote?
To the best of my knowledge. With reference to the amendment which was rejected,
Yes.
that was in, I believe it was the first volume of the 1957 volume of the Yearbook of the ILC, that the amendment...
Can you use a rejected amendment to support a case? Can you do that?
Yes, Your Excellency. In that case, now, the respondent has suggested that immunity should subsist with regard to all acts performed by a diplomat during his accreditation. However, this amendment, which was rejected, was an amendment to the last sentence of Article 39.2, and it would have changed the wording to say that, however, with respect to acts performed by such person during the exercise of the functions as a member of the mission, immunity shall continue to subsist. Now, that would have granted permanent immunity to all acts committed while the person was accredited.
What actually do you mean, Agent, by permanent immunity?
The receiving state would be precluded from exercising its jurisdiction over the former diplomat even after he had left the receiving state. Now, if the ILC had adopted this amendment, then the applicant would agree that we would be precluded from exercising our jurisdiction in this case. However, the ILC stated that they felt that immunity should continue to subsist only with regard to this specific type of act, the acts performed in the exercise of diplomatic functions.
I wanted to ask a question with respect to that. You're drawing an important distinction here between acts performed in the diplomatic function as compared to other acts, presumably, that are not performed in the diplomatic function. And you're saying that during the period that the diplomat is accredited, he's immune from criminal prosecution with respect to acts of both classes. But after his service has terminated, he's left the country, he's no longer credited that country, he can then be prosecuted with respect to acts committed while he was a diplomat, but were not part of his diplomatic function. Is that correct?
That's correct.
Now, what is the rationale for such a distinction? Why would we say you can't be prosecuted while you're a diplomat, but after you're gone, if we can catch you, we can prosecute you and presumably, submit you to the death penalty for what you did when you were accredited to our country, but violated some act of our country. I mean, for example, you might have killed a grizzly bear out in Yellowstone Park while you were on a vacation, okay? Not part of your diplomatic function. You couldn't be prosecuted for that while you were accredited as a diplomat, okay? But now you're no longer a diplomat, and although you were accredited as a diplomat at the time, if we can catch you after you leave, we can hang you. Now, what is the rationale for such a distinction? What's the purpose of it?
The justification for granting diplomatic, I see my time is quite limited. If I could just answer your question and then have a minute to conclude.
Defer to the President.
Please indicate the purpose of diplomatic immunity.
The justification behind the granting of privileges and immunities is to ensure the efficient conduct of diplomatic relations. Now, this is based on the functional necessity theory of diplomatic immunity. Diplomats are granted immunity to protect them from potential harassment or coercion by the receiving state and to avoid the possibility of their time being used up by numerous court appearances. Now, it's important to note that the focus is on the facilitation of the performance of the diplomatic mission as a whole and not the individual involved. Prosecuting a former diplomat for acts totally unconnected with his diplomatic functions will not hinder the performance of the diplomatic mission. It will simply deter diplomats from committing criminal acts in the receiving state. Now, with regard to the situation you proposed regarding killing a grizzly bear in Yellowstone National Park, now, I should point out that the potential for a receiving state to exercise its jurisdiction over a former diplomat is quite limited. It would only occur in situations where the former diplomat either returned voluntarily to the receiving state or was extradited back to that state. And in the latter case, the law regarding extradition provides certain safeguards against a receiving state abusing its power to assert jurisdiction. For instance, there's the requirement of double criminality. There are several grounds for refusal of a request for extradition, such as the likelihood that the person will not receive a fair trial or that the death penalty may be imposed. And in terms of Anglo-American practice, the state that is requested to extradite an individual requires the requesting state to make out a prima facie case against the individual. Now, this would limit the possibility of a receiving state attempting to prosecute a former ambassador on trumped-up charges. If I may have a moment to conclude.
You may proceed.
For the reasons given, the applicant requests that the court deny the respondent's request for the provisional release of Ambassador Quintero and the dismissal of all charges against him. The applicant further requests that this court declare that Majan may criminally prosecute former Ambassador Quintero consistently with its obligations under the Vienna Convention on Diplomatic Relations. Permitting flagrant abuses of diplomatic immunity to go unpunished is, in the long run, a greater threat to the stability of diplomatic relations than permitting a receiving state to prosecute a former ambassador for the serious crimes such as these. If there are no further questions, that concludes the applicant's.
I have one single question before you go. At your page 6, you made a statement that troubles me. You said that there is no reason in principle to distinguish between criminal and civil actions. What do you mean by that?
The Vienna Convention has already distinguished between civil and criminal
Then why do you say
jurisdiction.
there's no reason to make such a distinction?
In terms of the duration of diplomatic privileges and immunities, there is no reason to distinguish between the two types of action. In terms of how broad we wish to make the immunity from the jurisdiction, there is more reason to provide immunity from criminal jurisdiction than from civil, because it is more likely to be abused by a receiving state. However, the duration of both of these types of immunity is granted and covered in the same provisions, and there's no reason to believe that the duration should be any different in terms of civil actions than in terms of criminal actions.
Thank you.
Thank you.
Counsel for Majan, you may proceed.
Mr. President, Your Excellencies, may it please the Court, again, my name is Catherine McHenry. I will be speaking to the second issue, the seizure of assets, on behalf of both Majan and the International Monetary Union. At stake in this second issue is nothing less than the independent capacity of an international financial organization to perform functions on behalf of economically less developed nations without interference from economically stronger powers. The central issue before this court today is the sovereign right of every nation to protect its people through the exercise of valid criminal jurisdiction. Neither the relative strength of the Majani economy nor Majan's central banking arrangements should have any bearing on that issue. And yet, the Majan economy has been paralyzed, as has its central banking functions.
Could you explain in what way Majan's economy has been paralyzed? Could you explain the nature of this organization? Are there parallels to it elsewhere? I mean, this is a large organization, but obviously it's very different from the International Monetary Fund. Are there other examples that can help us so we can get some idea as we compare this organization with others and its role here and the importance of it to the Majan's economy?
Your Excellency, as I begin the substance of my argument, I will be drawing your attention to Foreign State Sovereign Immunities Acts and drawing your attention, in fact, to the immunities which attach to the central banking functions of states worldwide.
Counsel, which foreign sovereign immunities
Foreign
act?
sovereign-
Which act is that?
There are-
Canadian act? What kind of act?
There are a number of such acts, Mr. President. They include the Foreign Sovereign Immunities Act of 1976 in the United States, the State Immunity Act in Canada of 1982, the UK State Immunity Act of 1978, the Singapore State Immunity Act of 1979, the Pakistan State Immunity Ordinance of 1981, the South African Foreign State Immunities Act of 1981, and further, that language contained in these acts is reflected in the United Nations, in the Draft Convention on Jurisdictional Immunities of States and Their Properties, provisionally adopted by the ILC in 1986.
The question I have, though, here is, you mentioned that the action here has virtually paralyzed your economy. And I wanted to explain how that came about. What is the nature of this monetary union with the centralized currency reserves, where you have, your country has in effect delegated to an international organization the authority to set interest rates on your currency, that the matter of collection of payments for your economy is handled through this international organization, through these administered accounts. Can you explain some aspects of this organization? Because one of the things that's difficult for us is to understand how this organization works, and further to understand, because international organizations cannot be parties to contentious cases before this court, how this court can deal with the issue that is posed by the issue you're presenting here.
Yes, Your Excellency. To clarify our position, this court will be hearing, and is hearing, arguments pertaining to two separate disputes. There is the dispute with respect to the IMU, and the IMU is asking this court, through Majan, to formally declare that assets held by it in the course of its functions as a central banking and monetary authority are immune from the seizure of the government of Aristan.
Is this a way to circumvent the provision of the statute of this court that only states can be parties to contentious proceedings, Counsel?
It certainly is not, Your Excellency. In fact, under Article 36(1) of the ICJ statute, it is set out that the jurisdiction of the court comprises all cases which the parties refer to it, and all matters specially provided for in the Charter of the United Nations or in treaties and conventions in force. The parties to this case before you have specially agreed to forward the case to this court and to be decided under your jurisdiction.
I understand what the parties have agreed, but obviously the parties cannot confer competence on this court that relates to what the parties to the statute have given authority to the court to decide.
Your Excellency, under Article 38(1), this court shall apply international conventions, whether general or particular, establishing rules expressly recognized by the contesting states. The rules by which the IMU is to be represented by Majan are contained in special treaties between the IMU and all of its member states.
Are your government really representing IMU, or does it have an interest in these funds that is sufficiently significant so that in fact it's arguing its interest as a party before this court as compared to simply serving as the agent for an international organization that cannot be a party to a contentious case?
Your Excellency, I believe you're referring to the 1966 Southwest Africa decision.
I'm referring to the principle in the question, but if that case can be helpful to the court, certainly.
I believe that that case can be helpful to the court, Your Excellency, inasmuch as it was established there by this court that where a country has a legal interest in a dispute, that where that country has a special agreement with a party which is not a state, that country may represent international interests of that organization before this court.
Counsel, can a non-member of a treaty be bound by such a treaty? A non-member of a treaty, can he be bound by such a treaty?
Only through the operation of customary law, Your Excellency.
And what is the customary international law in this very particular situation? How can you define customary international law? Just read Article 38, which I'm glad to hear. How do you understand customary international law?
Customary international law, Your Excellency, is a combination of state practice and opinio juri, or the obligation of states to practice in that manner.
So you are saying that Aristan has indeed recognized the existence of IMU, is that correct?
It certainly regards the IMU as a regional organization, separate and independent.
And then in that regard, you would like this court to rule on the basis of estoppel doctrine. Do you know what estoppel doctrine is?
Yes, I do, Your Excellency. And it's...
Remember, in the case, could this court have decided on the basis of estoppel doctrine?
I don't have that case at my fingertips, Your Excellency. However, I do realize that the estoppel doctrine is prevalent or is available at international law, although its position is not as clear as it would be in domestic law. It is not the doctrine of estoppel that is the primary contention of the applicants, or which the applicants are primarily relying on in this case. Rather, it is the issue of functional necessity and how functional necessity defines the scope of an international legal personality.
Excuse me, Counsel, can you explain why these funds were held with a commercial bank In other words, here you have this international organization holding this account that is going to be administered for the benefit of your country. Why are these assets held with a commercial bank of a country that's not a party to the regional organization? How did that happen? Is there a rationale for that so we can understand what's involved here?
Certainly, Your Excellency, there is a rationale. It is perfectly consistent with any central bank's functions to maintain accounts in private banks in economically more powerful countries. The reason is this. The International Monetary Union appears to be, according to the compromis, a collection of regional developing states. These states, by definition, will not have strong currencies. The function, then, of the International Monetary Union is to stabilize monetary policy across its 61 member states. In order to do that, and in order to keep monetary policy stable and in line with the global economy, it is necessary to maintain accounts in foreign banks in foreign currencies.
So presumably then it's maintained account because the currency of the respondent in this case is a currency that's widely used for payments from your nationals and to your nationals in connection with international transactions. Is that what you're saying?
In connection with international transactions in this sense, Your Excellency, these funds are not tied to any particular commercial transaction and therefore cannot be described or defined as
they're available. In other words, presumably if there were payments to be made to nationals in your country, they might be made in that currency of the respondent in this case, which would be deposited to an account with the IMU, being administered by the IMU for the benefit of your state. Is that what you're saying?
No, Your Excellency, that is not the contention of the applicants in this matter. The contention of the applicants is instead that those funds would be released to the government of Majan or to its 61 member states in order to support the monetary policy which is defined and decided by the International Monetary Union. The functions...
What is the distinction, Counsel, between economic coercion and reprisal? What's the distinction between the two?
Your Excellency, economic coercion can be a form of reprisal. Economic coercion in recent United Nations resolutions has been defined in terms of the principle of non-intervention in international law, and eminent scholars have further carried on with that definition. What is happening in the current situation is that Aristan has implemented measures of severe economic coercion against Majan and against third states. In other words, Aristan has pressured third states into cutting off trade or cutting trade down at least to a trickle, getting into Majan. That is a clear violation of the principle of non-intervention in international law.
Council, has any of the third states protested against this coercion?
There is no evidence to that effect, Mr. President. However, it is stated in the compromis that these states have been pressured. And given that these are neighboring states to Majan, it is not difficult to assume that these are also developing weak, economically weak nations, which would be easily coerced into cutting off trade with another developing nation by a more developed nation. Now, coercion in the context of reprisal, to get back to Your Excellency's earlier question, is possible in the event that the full three conditions for reprisal are met. In this case, it is the contention of the applicants that those three conditions are not met, and for the following reason. The three conditions for a valid reprisal were set out in 1930 in the Nalila case.
What case?
The Nalila case, in 1928. It's an arbitral tribunal award. And in that case, it was set out that the three elements of a valid reprisal are, first, a prior illegal act on the part of the allegedly injuring state. Secondly, that all other means of redress have been satisfied. And thirdly, that the reprisal be proportionate. In the first instance, there has been no prior illegal act on the part of Majan. In the second instance, Aristan was perfectly free to come before this court and bring Majan before this court before implementing its economic measures of coercion against Majan. Finally, there is the proportionality requirement. Now, in the proportionality requirement, it is of course difficult to distinguish what would be proportional to a prior violation of international law when the retaliatory measures are not exactly the same as the prior alleged violation. However, in this case, the alleged violation is the arrest and prosecution of one former ambassador for heinous crimes within the country of Majan. In response to that, Aristan has implemented these measures of economic coercion to the extent that they have violated the principle of non-intervention, both with respect to Majan and with respect to its trading partners. Furthermore, there is no precedent in international law where one country can take retaliatory measures against a third party to a dispute. The IMU is not a party to the dispute between Aristan and Majan. The IMU is a separate, independent legal personality fitting the criteria set out by this court in the reparation for injuries suffered in service of the United Nations case in 1949.
On what legal basis do you base the legal personality of IMU? Do you equate it in the same manner as the International Monetary Fund? Do you see it exactly in the same manner?
I do not see it in exactly the same way in this sense, Your Excellency. The International Monetary Fund is a specialized agency of the United Nations and is quite universal in character. The reparations case did, however, set out the preconditions for establishing objective legal personality, and those preconditions include one single central organ, an independent will, that the organization be created to operate on an international plane, and finally, and a key criterion, is the fact that this organization have the capacity to conclude treaties. Now, it has been set out by Professor Skamers, among others, that there is no need for legal personality to be expressly recognized in an organization's constituent documents or in municipal legislation. Now, to relate to you why the IMU is an international legal personality, it has at its heart one single central organ, which is the central bank and monetary authority for 61 member states. It legislates monetary policy for its members, and it has separate financial means. These indicate that it has an independent will. Third, this organization must operate on an international plane in order to integrate the monetary authority and central banking functions for its 61 member states. And finally, it is expressly able to conclude treaties both with members and with non-members alike. Now, international legal personality and the designation of that does not automatically confer upon the International Monetary Union immunities and privileges with respect to its nature. Rather, those must be established according to the functional necessity theory of privileges and immunities originally adopted by this court in 1926 and since adopted...
This court adopted?
Excuse me, Mr. President, the predecessor to this court.
The Permanent Court of International Justice.
The Permanent Court of International Justice, that is correct, in the ILO advisory opinions in 1926. It received its definitive statement in the reparations case cited earlier, and that statement is that the rights and privileges to which an international organization is entitled are determined according to its purposes and functions, as implied or stated in its constituent documents. And where such international legal personality exists, it will exist in customary international law.
Counsel, can you clarify the relevance of immunities or privileges of international organization to the present case?
Yes, Your Excellency. The IMU is an international organization in the tradition of international organizations which have been developing since the Second World War. Since the Second World War...
Counsel, what is your definition of, or the use of term international organization? What do you understand by it?
I understand that it is an organization which is created among states to operate on an international plane. Mr. President. This particular organization and international organizations in general are non-territorially based. They must have privileges and immunities in order to effectively perform their functions. As Professor Jenks has put it, the provision of privileges and immunities to international organizations is neither merely a housekeeping problem for those organizations, nor an insidious encroachment on the equal application of the rule of law, but rather is an essential device for protecting these organizations from unilateral and sometimes irresponsible interference by individual governments.
Let me just juxtapose one other question that I think is relevant here. When an ambassador commits an offense in the receiving country, what are the two remedies available to the receiving country in terms of the action of the ambassador?
The country may declare that ambassador persona non grata or request a
Why
waiver.
didn't the government do that?
In order to expel the ambassador from the country.
Right. Why didn't they do that?
Why didn't they do that in the instant case, Your Excellency?
Right.
The remedy of persona non grata in the instant case would be an illusory remedy. In fact, the ambassador had already been allowed to leave the country and had gone to Aristan, where Aristan was perfectly free to assert its own valid criminal jurisdiction. However, Aristan refused to exercise that jurisdiction.
Did your government ask Aristan to do that?
To exercise criminal jurisdiction?
Right.
No, Your Excellency, it did not.
Why didn't you?
We did not ask for that remedy because it was Aristan's obligation at international law to exercise criminal jurisdiction where the offense is a serious one within the receiving state. To come back to the immunities of the International Monetary Union, those immunities are established according to what immunities are necessary to the functions of a central bank. Immunities...
Counsel, I'm wondering, even if this was not an international monetary union, even if this was only an ordinary foreign private commercial bank, could you seize the property of this bank?
No, Mr. President, not without compensation. Compensation would be required under those circumstances. However, that is not the case before this court today.
But the court would like to hear your arguments on the second limb with regard to the immunities of the assets of Majan. Are you getting down to that?
I think the question we're asking is, suppose that these were assets of Majan, there wasn't an international organization involved at all, but Majan was in full control of its monetary policy, owned the assets, and its central bank was holding those assets with the commercial bank in Aristan. And the International Monetary Fund was not, organization was not involved because it wasn't a member. It was managing its own affairs. Would those assets then be immune or not immune from seizure?
Your Excellency, in the event that those, I see that my time is up. If I may answer your question and then continue to a short conclusion. In the event that these assets were maintained and held by Majan in the state of Aristan, certainly sovereign immunity would attach to those funds. However, in the event that Aristan were able to found its claim validly that Majan had breached international law, there is the possibility of a reprisal. And we have discussed why, in this situation, reprisal would not be appropriate, because the three conditions for reprisal have not been satisfied. That is, the prior illegal breach, the other means of redress have not been exhausted. And thirdly, that Aristan's reactions are completely out of proportion to the arrest of one former ambassador for drug smuggling and killing people in Majan. If I may just conclude briefly.
You may proceed to conclude.
Majan's status as an equal independent sovereign and the IMU's status as an independent subject of international law will be determined by this court today. The new international economic order, based on the twin principles of equity and justice, hangs in the balance. To ensure that these twin principles of international law are satisfied, the applicants request that this court grant the prayers for relief set out at page 25 of the applicant's memorial, and in particular, that you declare that Majan may prosecute Ambassador Kitaro fully consistently with its obligations under international law. Secondly, that this court declare that the assets held by the IMU for the benefit of Majan on an administered deposit account with the First Aristani National Bank are immune from seizure by the government of Aristan. And thirdly, that this court declare that Aristan's combined measures of economic coercion and asset seizure are illegal at international law. If there are no further questions, that concludes the submissions of the applicants on this matter.
Thank you.
Agent for Aristan, are you ready? May proceed.
Mr. President, Your Excellencies, my name is Wayne Morgan. I appear with my co-agent, Miss Penny Matthew, for the respondent, the United Republic of Aristan. Your Excellencies, Aristan requests two declarations from this court. Firstly, that the former Ambassador Kitaro is immune under the Vienna Convention on Diplomatic Relations. Secondly, that the funds assigned to Majan on the administered deposit account with the IMU are not immune from seizure. I shall be dealing with the first of these declarations. My co-agent will be dealing with the second. Your Excellencies, with regard to the first declaration, that the applicant's prosecution is illegal, I have three main submissions. Firstly, that under the Vienna Convention on Diplomatic Relations, the former ambassador retains absolute immunity after the period of accreditation for the acts for which the applicant complains. Secondly, that there is a rule of customary international law that no diplomat will be prosecuted either during or after the period of accreditation. Thirdly,
What is customary international law? What is customary international law? How do you understand it?
Your Excellency, under Article 38(1)(b) of this court statute, customary international law is the practice of states which they regard as binding on them as law. The Vienna Convention itself in the preamble does allow reference to customary law. Your Excellencies, as a third and subsidiary submission, it is the applicant's submission that the present prosecution by the applicant is in breach of the former ambassador's human right to a fair trial. Your Excellencies, with regard to the first submission, Aristan submits that the interpretation which this court should give to Article 39, paragraph 2, is indeed the crux of this issue. The applicant submits that the second sentence of this paragraph does not confer continuing immunity on the former ambassador. Aristan rejects this contention. It is Aristan's submission that the acts for which the applicant complains are indeed comprehended under this second sentence. This follows, firstly, from the words of the Convention itself, particularly Article 38 of the Convention, and from the travaux preparatoires to the Vienna Convention.
Agent, what has Article 38 got to do with Article 39, paragraph 2?
Your Excellency, Article 38 deals with the immunities which are granted to an agent who is also a resident of the receiving state. However, when talking of those immunities, it uses exactly the same words as Article 39, except for one important omission. This fact, coupled with the fact that the two articles immediately follow, Article 39 immediately follows Article 38, it is Aristan's contention that this provides evidence of the different meaning of the two articles.
But what about Article 37, Agent?
Certainly, Your Excellency. Article 37 does not use exactly the same words. I believe
But the Convention is free to use different wording for different provisions of the same.
Yes, Your
treatment.
Excellency. However, when they are dealing with the same issues, that is the immunities which are granted to agents, they are therefore...
Which you say is absolute.
Under Article 39, paragraph 2, yes, and this follows from the different words.
If it is absolute, then why have they gone to the extent of drawing the line of distinction between acts performed in the exercise of functions of a member of the mission and acts performed outside, or not in the exercise of the function?
Your Excellency, the first thing to establish in this regard is that the second sentence of Article 39.2 is not confined to official acts. And this is our contention. It follows from Article 30.
Be it as you may argue, not confined to official acts, that it is conceivable that you can have non-official acts, but then they have to be performed, I didn't say committed, but performed in the exercise of function of a member of the mission.
Yes, Your Excellency. It is Aristan's submission that the second sentence of Article 39, paragraph 2, must be interpreted on a case-by-case basis according to the status of the diplomat involved. The Vienna Convention itself, and indeed a comparison with the Vienna Convention on Consular Relations, recognises that differing degrees of immunity are indeed granted according to the status of the diplomat involved.
Agent, on a case-by-case basis, on the facts of this case, are you suggesting then that the acts performed by Ambassador Kitaro have been in the exercise of the functions as diplomatic agent?
Yes, Your Excellency, that is Aristan's submission. In having regard to the principle of functional necessity, which is embodied in the Vienna Convention on Diplomatic Relations, and the possible abuses which a diplomat is open to, even under the threat of post-accreditation prosecutions. It is Aristan's submission that the widest possible interpretation must be given to the ambassador's immunities because he is an ambassador. He was the supreme representative of Aristan in the receiving state.
Are you saying, Counsel, that an ambassador is free to do anything he deems wise in the receiving country?
Your Excellency, with the exception of crimes against humanity, the prohibition on which is a peremptory norm of international law, with that exception, an ambassador is indeed immune from the criminal jurisdiction completely, both during and after the period of accreditation.
How about drug dealing? Assuming that he engages in drug, which kills many kids and young people, would the ambassador also not be prosecuted for that?
No, Your Excellency, not in the receiving state. He may not. Drug smuggling is not a crime against humanity. It was specifically...
But it kills people, doesn't it?
Certainly, Your Excellency. However, even
What is humanity? How do you understand humanity?
Your Excellency, the word humanity obviously has different meanings according to its context. The meaning of the term crimes against humanity is quite specific. It is a recognised group of crimes, for instance, piracy, war crimes, a specific group. Drug smuggling is not a member of that group of crimes. Your Excellency, I would also wish to point out that the remedies of a receiving state in this regard are well known.
Excuse me, Counsel, I want to be sure that I understand the argument you're making here, Mr. Mark. Are you suggesting that the last sentence of paragraph 2 of Article 39 of the Vienna Convention on Diplomatic Relations, which reads, however, with respect to acts performed by such a person, the exercise of his function as a member of the mission, immunity shall continue to subsist after something. You're suggesting that that really should be read, however, with respect to act performed by such a person as when a member of the mission. Just read out the language, exercise of his function, that's irrelevant, that the only qualification is whether he's engaged in acts that are against rights of humanity. So you're suggesting then that in effect this court rewrite the last sentence of paragraph 2 of 39. Or are you suggesting something less?
Your Excellency, what we are submitting is that the words of Article 39.2 are ambiguous. They therefore must be interpreted in light of the objects and purposes, both under Article 31 of the Vienna Convention on the Law of Treaties and as that convention does not specifically apply to the Vienna Convention, under customary international law, this is a requirement of the interpretation.
Is the exercise of his functions that ambiguous, Mr. Moore? I mean, does that mean that if you, for example, if a diplomat should father a child out of wedlock, that should nevertheless be read as part of his diplomatic functions? Exercise of diplomatic functions so that he could not be prosecuted for that, would not be subject to jurisdiction ex post with respect to the child that might have been fathered, for example?
Your Excellency, it is Aristan's submission that in that regard it may not necessarily be included under the second sentence. However, that will depend on the status of the diplomat involved.
In other words, if he's the most senior person, he could engage in the act that I've talked about and would not be subject then to the exercise of jurisdiction ex post with respect to support of that child that was fathered, for example, while he was an ambassador.
Yes, Your Excellency, that is Aristan's submission. As I submitted, it is clear under the Vienna Convention itself that different immunities are indeed granted according to the differing status of agents. It is therefore our submission that this in no way contradicts and indeed is supported by the purpose of the Convention.
But Agent, one question following from my brother questioning, but is Aristan a believer in human rights?
Certainly, Your Excellency.
But the right of the unborn child, if the child was thereafter born alive, would the child not be able to exercise his right of action against the father once his term of office has been terminated or ceased?
Your Excellency has indeed posed a difficult question. Luckily, those facts are not before us. However, in that regard, I would say firstly that certainly during the period of accreditation, there would be no remedy against the diplomat in question. And it is indeed Aristan's submission that depending on the status of the diplomat in question, indeed there may be no remedy after the period of accreditation. I would stress, however, in the receiving state. In the sending state, under Article 31, paragraph 4, the sending state at all times retains jurisdiction over any of its diplomats. And indeed, in that case, the mother or the child could seek to bring an action in the sending state itself. Therefore, there are remedies providing. These remedies are well recognised. Your Excellencies, in that regard, this court in the Tehran hostages case specifically stated, and if I may quote from paragraph 86, the rules of diplomatic law, in short, constitute a self-contained regime which on the one hand lay down the receiving state's obligations and on the other specifies the means at the disposal of the receiving state to counter any abuse of diplomatic privileges. These means are, by their nature, entirely efficacious. Your Excellencies, the means which the court referred to are indeed well known. They include waiver under Article 32 of the Vienna Convention on Diplomatic Relations. At no time did the receiving state in this case request a waiver. They include declaring the diplomat persona non grata. That also did not occur in this case. Majan did not request Aristan to prosecute the former ambassador. Instead, it took a remedy which is outside the Vienna Convention on Diplomatic Relations. In this regard, it is Aristan's submission that the applicant's action was illegal under the Vienna Convention on Diplomatic Relations. Your Excellencies, it is our further submission that there is a rule of customary international law that no diplomat will be prosecuted either during or after the period of accreditation. As I stated, customary international law may be looked at under the preamble to the Vienna Convention on Diplomatic Relations. In this regard, the applicant did point to some state practice which the applicant asserted was recognising that diplomats could be prosecuted post-accreditation. In this regard, they pointed to the Abyssinato affair, which involved a Papua New Guinean ambassador who committed acts in the United States injuring...
Counsel, if I may ask you a question. Does the government of Aristan recognize the existence of IMU?
Your Excellency, the compromise states that the government of Aristan regards the IMU as a regional organisation. Now, it depends exactly what you mean by recognition, not in the legal sense.
For how long has that occurred? 2 years, 3 years, or 4 or 5 years?
The compromise simply does not reveal, Your Excellency, for how long that has
Now,
occurred.
the reason I ask you the question, Counsel, is because you continue to cite customary international law, which of course refers to state practices and so forth. Now, if Aristan has indeed recognized the existence of this regional organization called IMU, wouldn't you concede the fact that the mere recognition of the existence of IMU would mean indeed that that organization exists as an international organization within that region?
Your Excellency, Aristan does not dispute the existence of the IMU as an organisation. It disputes the immunities which are conferred on this organisation, and indeed these submissions will be made by my co-agent, although if Your Excellency has further questions, I will attempt to answer them.
We're only interested in trying to find whether there's inconsistency in state behavior with regard to Aristan, and this is really what I'm heading to, in terms of the behavior of your government in this regard. But you are saying that there is a distinction between a mere recognition, which you may call de facto recognition, if you will, as distinct from the jure recognition of an organization. Is that what you're saying?
Yes, Your Excellency. It is our submission that the mere fact that Aristan regards the IMU as a regional organisation says nothing about the immunities which that organisation has. If I may use an example, Your Excellency, just because the United States of America may recognise the European Economic Community or may regard it as an international organisation, this would not mean that it was bound by any treaties which conferred immunities on that organisation. And Aristan is not a party to any treaties conferring immunities on the IMU. Your Excellency, I see I am running short of time.
To follow the same question, there was a case before this court previously in regard to a case between Thailand and Cambodia. It was called Siam at the time. Are you aware of that case?
The Temple of Priya case?
Yes. How do you understand the Temple case?
Your Excellency, that case did involve the concept of estoppel. The exact facts of that case escape me, but one of the parties was estopped from denying that a temple was within the other state's territory because it had knowledge of maps in which that temple was placed in the other state's territory.
In other words, aggression by map?
Excuse me, Your Excellency?
Aggression by map?
Aggression.
Or acquiescence of aggression by map?
Just to, just to round it up, what was involved, and I'm glad you made a good recollection of the situation, what was involved is the fact that the French, which was the colonizer of one of those governments there at the time, did publish a map which was recognized by both sides. And on the estoppel doctrine, if there was a recognition, a failure to continue the recognition would mean inconsistency in behavior. And in which case, of course, the principle of estoppel would be applicable. Are you saying that it's not relevant to your case?
Yes, Your Excellency, we are. We submit that Aristan is not estopped from the mere fact that the compromise states it has regarded, it has been aware of the IMU as a regional organisation. This says nothing about the immunities under customary international law or under treaty, which
how do you want us to rule here? That's the final question. Do you want this court to rule on the principles as understood
within customary international law, or do you want this court to rule on the principle of treaty law? How do you want us to rule?
Your Excellency, it depends with which declaration you are considering. If you are talking of the first declaration dealing with the former ambassador's immunities, we primarily rely on the Vienna Convention itself, which we submit, states that the former ambassador may not be prosecuted. However, when we are dealing with the second declaration, because there is no treaty which Aristan is a party to, it is customary international law and the immunities under customary international law which must be looked at in this regard.
Thank you very much.
Your Excellencies, I see I am very short of time. On the issue of customary international law and the regard of prosecution of diplomats, I would merely state that the overwhelming state practice is that non-prosecution is the rule. There have indeed been cases of equally serious crimes involving drug smuggling and murder where diplomats have not been prosecuted either during or after the period of accreditation. It is Aristan's submission that this state practice is in conformity with the Vienna Convention and shows the international law on this issue. Further, Your Excellencies, the third submission with regard to the ambassador's human rights. It is Aristan's submission that the ambassador's human right to a fair trial will be abused in the state of Majan, and this is a further reason why Your Excellencies should uphold his immunities under the Vienna Convention on Diplomatic Relations. Your Excellencies, because I am so short of time, unless Your Excellencies would like to hear specific argument on that issue, I will direct you to the memorial and sum up.
You may sum up.
Your Excellencies, Aristan does not condone the acts of which the former ambassador is accused. We do not, indeed we cannot defend the former ambassador. What Aristan does defend, however, are the extremely important principles of diplomatic law, diplomatic immunities, which are necessary for the continued effective functionings of international relations. We therefore request that this court indeed declare that the former ambassador is immune under the Vienna Convention on Diplomatic Relations. Your Excellencies, that concludes my submissions.
Thank you.
Thank you.
Co-agent for Aristan, you may proceed.
Mr. President, Your Excellencies, my name is Penny Matthew and I appear as agent for Aristan, the respondent in this case.
You appear as agent or as co-agent?
As co-agent, Mr. President.
Thought maybe confused.
Your Excellencies, I will be dealing with the issue of the seizure of the funds in this case. It was in response to Majan's action of trying our former diplomat that Aristan took the action of seizing the funds on the administered deposit account with the International Monetary Union, or IMU. It's Aristan's submission that this act was permitted at international law. Firstly, as an act of retortion.
Excuse me, Counsel, if I can interrupt. Concerned about the magnitude of what was done here and the consequences. As I understand it, the International Monetary Union is a regional organization of a large number of states, in which those states have surrendered their sovereignty in monetary areas in a way that is really quite remarkable, isn't it? That is that they have agreed to centralize their monetary reserves, as to compared to hold them with their own monetary institutions. They've agreed to surrender their rights to set the interest rates, to surrender the rights as to the liquidity of funds in their economies, that they have common banking legislation and a single currency. So in effect, this organization is performing the functions normally performed by a state that are at the heart of sovereignty. And with respect to those funds, then, the organization has chosen to place those funds with a bank in Aristan, presumably because the currency of Aristan is a widely traded currency and is needed for international payments of the members of this monetary union. And my question comes up in context of that question with respect to pages 16 and 17 of your state's memorial, where you state that the sovereign immunity for government reserves is only available to funds which have an official function, application. In what sense do these funds not have an official application? They appear to be the very center of sovereignty of the applicant state here. I mean, in what way are they non-official? I don't understand the argument you've made on page 16 and 17.
Yes, Your Excellency. Our submissions are that whether we are looking at the IMU's claim or Majan's claim, a restrictive theory of immunity does indeed apply, and that for funds which are used for a commercial application, no immunity will apply. The evidence in the compromise does not show that the funds will be used for any official purpose, Your Excellency. The evidence that we have is that the funds have been assigned to the state of Majan and then deposited by the IMU in a private commercial institution in the state of Aristan. Now, there is much municipal legislation which has been cited both by the applicant and the respondent in this state, which determines that a loan is a commercial transaction. It's Aristan's submission that a deposit with a bank establishes a loan contract. The bank...
Are you suggesting that every deposit account is a non-official application of funds? Is that
yes, Your Excellency, that is Aristan's submission.
So that when the Central Bank of Iran maintains an account with Citibank in New York, that's non-official function, even though it might compose of even potentially the total monetary reserves of that country.
Your Excellency,
not official. It might be used to finance their embassies, to pay the salaries of persons for their missions to the United Nations, but nevertheless not official. I don't understand the argument you're making, Counsel.
Your
I wonder if it's much broader than you need to make.
You refer then to the purposes of a fund of the Iranian government. Now, if it was possible to determine what the purposes of these funds were, then Aristan might concede that immunity applies. But in this case, there is no evidence as to the purposes for which these funds will be used. There is only evidence of the nature of the transaction. And it's Aristan's submission that it is indeed the nature test for determining whether there will be a commercial or official transaction occurring here.
It could be the entire monetary reserves of this country. There's nothing in the compromise that in any way suggests that there are any others. All of their monetary reserves are centralized with IMU. There's nothing in the compromise that doesn't indicate that 100% of those reserves aren't placed with this bank, so that all the monetary reserves of this state potentially are the subject of this case before this court. I mean, you've literally bankrupted the state. You've literally bankrupted a state. You've prevented that from engaging in international transactions of any type whatsoever.
Even on the hypothesis that you have suggested, Your Excellency, it is still Aristan's submission that what is being engaged in here is indeed a commercial transaction, a loan with the bank, and the bank presumably has to pay interest. That is a profit-seeking enterprise.
Well, Agent, I very much doubt your suggestion. Please clarify that is the dispute in any way related to the transactions in question, the loan? Who are the parties to the loan?
Your Excellency, the parties to the loan are the IMU, the depositor, and the First Aristani National Bank, a commercial institution.
And that is not before this court or before the court in any country?
So Your Excellency is suggesting that the IMU has no standing in this case?
I'm not suggesting anything. I'm merely asking you to clarify the relevance of the so-called transactions.
Your Excellency, it's Aristan's submission that indeed the nature of the transaction is relevant. When looking at whether...
But we are not, we are not concerning ourselves with the transaction. We are concerned with the assets. The immunity is from seizure and attachment, and not from the jurisdiction, not from litigation.
This is not a case, counsel, is it, where we're dealing with a shipping company's account, and we have a case in which a shipping company has violated some contract, and there's a suit and a judgment against that shipping company. Then we want to enforce that judgment by attaching the shipping company's account, and it happens that the shipping company is government-owned. We're not dealing with that kind of case, are we?
That's absolutely correct, Your Excellency. But it's our submission that if any immunity attaches to these funds at general international law, it must either be sovereign immunity claimed by the state of Majan or some form of organisational immunity claimed by the IMU, and the applicant has the onus of establishing this. It is a fundamental principle of international law under the Lotus case that a state may do whatever it wishes under its own municipal legislation unless there is an international law to the contrary. Aristan seized these funds pursuant to its economic emergency powers legislation, and it was entitled to assume that it had territorial sovereignty over funds within its boundaries, Your Excellency. Unless the applicants can show that there is some immunity which protects these funds, Aristan is entitled to seize them. The only...
That's what they've argued. They've argued that precisely that, haven't they?
Certainly.
In their argument that they have made an argument that these funds are entitled to immunity. I mean, that's what they did. So you can't say that they haven't made an argument. How do you counter the argument that they've made? It seems to me the Lotus case is quite beyond us here. We're way beyond the Lotus case.
Your Excellency, the applicant submitted that sovereign immunity applied. It is our submission that sovereign immunity does not apply when looking at the claim of Majan. Now, there are several tests for determining whether a state is engaging in jus imperii, or official transactions, or jus gestionis, or commercial transactions, Your Excellencies. For example, there is the purposes test.
Yeah, but we're talking again about the assets.
Assets, not the transactions.
Not the transactions.
But the assets, Your Excellencies, must be shown to be used for some official application in order to attract the rules of sovereign immunity. And it's Aristan's submission that there is no such official purpose.
Is that correct, counsel? You're suggesting that in order for central bank assets, for example, to be immune, you have to show the use of those assets, and only those assets that the holder of those assets can demonstrate are precisely used for an official function, okay, can be used, and assets that central bank reserves that may in some sense be used to facilitate the international transactions of the residents of a state are not immune?
Yes.
And how would you do that? Is there any state in the world where we can actually classify the assets into these two categories? Could you do that with respect to Australia or Canada or the United States or any country? Can you really classify the assets into those two classes?
Your Excellency,
what proportion are one or the other?
Yes, we can. You mentioned Canada and Australia. Now, in the Sovereign Immunities Acts of both those states, there is no specific provision that central bank funds are always used for official purposes. There is the distinction drawn that it must be shown that there is some official application of assets, as in this case.
Counsel, I note here that your government, your brief has cited Rosalind Higgins, and I'm particularly interested in your distinction between jure imperii and acts of jure gestionis.
Yes,
what is
Your
the
Excellency.
distinction between the two?
Jure imperii means an official transaction or an official purpose. Jure gestionis is the opposite, it's commercial. The rationale
So that is the distinction that you should have given to my colleagues. It's good for you to make the distinction and separate it and, of course, make your point.
Indeed, Your Excellency.
But how does this, with respect to the assets, if I can get back, I mean, it's one thing that you get a judgment against the central bank, for example, when it might, in some cases, be performing a commercial bank function, for example, issuing a letter of credit. And you get a judgment, okay, and then the question is how to enforce it. But you're not doing that here. There's no transaction for which you're seeking relief. You've seized the entire assets of the monetary union that are administered for the benefit of the applicant country.
Your Excellency, as I submitted, in various state immunity acts, including those of Canada and Australia, there is no special status given to a central bank that funds held by a central bank are in any way official. The usual distinction of jus imperii and jus gestionis applies. And we are submitting that in this case there is no evidence to show that the funds will be used for any official application, and therefore the rules of sovereign immunity may not apply if Majan seeks to claim them. Your Excellency, as regards the IMU's claim, there is no treaty between Aristan and the IMU. It is true that Aristan has always regarded this body as a regional organisation, but that does not mean it has regarded it as having any immunities. The applicants must show that there is some customary rule of international law which confers immunities upon this body, and that Aristan is bound by that customary rule.
Co-agent, is Aristan really bound by any customary rules of international law regarding seizure or forcible seizure of assets or property belonging to non-national, even though lying within the jurisdiction of Aristan?
Your Excellency, Mr. President, I believe you are referring to the rules of expropriation. It is Aristan's submission...
I'm referring to all kinds of seizure, attachment, expropriation, call it what you like, or sequestration by the executive, by the judiciary, or by the legislative for that matter.
Your Excellency, it's Aristan's submission that if there is no immunity attaching to these funds, that indeed Aristan may seize the funds. But further...
Even in violation of international law?
No, Your Excellency. An immunity which Aristan was bound by would indeed be a rule of international law by which it was bound, and it could not breach that immunity.
Are you suggesting that a sovereign state can always seize the property or assets of anybody, non-national?
No, Your Excellency. There are rules relating to expropriation of assets of a non-national. However, it's Aristan's submission that the rules of expropriation do not apply in this case.
For instance, public interest, for instance, non-discrimination?
Your Excellency, the first point about the rules relating to expropriation is that it refers to the taking of property, and firstly Aristan submits that there is no permanent taking of the property of a foreign national, that is a private individual or a corporation, as stated in the United States Third Restatement on Foreign Relations Law. What we're dealing with here is on the one hand a state or an international organisation. They are both entities which are governed by international law, and there is no...
What has the restatement of the US foreign relations law anything to do with international law?
Your Excellency, it's an example of state practice which this court may consider under Article 38, 1B of its statute.
Excuse me, I'm concerned, Counsel, about the conception of law that your state is espousing. You've cited the Lotus case. You've cited that the burden of proof of law, so to speak, is on the applicant on some of these issues. And it seems to me that you have a rather static view of international law, that it can only develop through treaties or somehow through state practice, but there's no role for this court in deciding disputes before us to play any role in the development of international law. Isn't one of the functions of the International Court of Justice, indeed, to play a role in the development of international law through cases that parties submit to us? And isn't that what's before the court here? So aren't we concerned here with what is wise in international law, what is necessary for good international relations? And the fact that the case is a fresh one, never been before this court before, never been considered in the same context by a national court, that doesn't mean that somehow we should wash our hands of it or say that we have to take a static view of international law and only look to what has occurred before. And so I would ask you, looking at the policies involved here and the issues of interstate relations, to address those questions and why the position that you're urging is a just one, is a wise one for this court to adopt. And not simply because we can't develop international law, we have to just leave it the way it was.
Your Excellency, firstly on the issue of immunity, and then as I'm running short of time, I will move to the issue of countermeasures. On the issue of immunity, it is our submission that a restrictive theory applies, and that is because commercial reality is that states and organisations should not be able to claim immunities where they engage in profit-seeking enterprises such as an ordinary individual could engage in.
What type of immunities are you referring to? Immunities from jurisdiction or immunities from seizure and attachment?
Both, Your Excellency. And sovereign immunity does indeed apply not only to the situation where there is an actual decision in a court being decided, but to the wider functions of a state. and that is the same with organisational immunities, Your Excellency. And it's our submission that states and organisations should not be able to claim absolute immunity for commercial transactions because they would be, in fact, disrupting the international trading system. Your Excellencies, moving to the issue of countermeasures. If this court should find that Aristan has breached an immunity belonging to these funds, it is Aristan's submission that we have taken a countermeasure, a legal countermeasure, against the act of trying our former ambassador. Countermeasures have been recognised at international law since the Naulila case cited by Learned Counsel.
Would you concede that if the trial of this ambassador is proper, that the countermeasure then is improper and that you lose completely in the case before the court?
No, Your Excellency, indeed we do not. The seminal case on countermeasures, which I wish to cite before this court, is the case of the Air Services Tribunal decision that involved a dispute between the United States of America and France over an aviation agreement. Now, the bench was composed of very eminent jurists, Roberto Argo, who is now a judge of this court, although he's not presiding today, and arbitrators De Vries and Reuter. The tribunal in that case said that there were two prerequisites for a valid countermeasure to have taken place. Firstly, a prior international wrong or a reasonable belief that a prior international wrong had been committed. My co-agent has presented arguments for why Aristan has a reasonable belief that the Vienna Convention on Diplomatic Relations has been breached in this case. So, Your Excellency,
how do you understand Article 59 of the Statute of the International Court of Justice?
there is no rule of stare decisis applying to this court, Your Excellency. I am submitting the example of the Air Services case as a very persuasive case for Your Excellencies to consider.
So you will say then that res judicata is irrelevant here. Am I correct that that's what you are leading to? Res judicata.
Your Excellency, I am submitting this case as an example of a decision which Your Excellencies may consider as relevant to the law on countermeasures. And indeed, there are other cases. Once again, the court is not bound, for example, by the Tehran hostages case, which considered countermeasures, and also the Nicaragua case, which considered countermeasures, but they are persuasive evidence for you to consider. I also submit evidence of the teaching of eminent publicists, which this court may consider under Article 38, 1D of its statute. The International Law Commission, in its draft articles on state responsibility, also recognised that a state may take countermeasures where its rights have been affected by a breach of international law.
How do you determine who is an eminent publicist?
That is a very difficult question indeed, Your Excellency. It would help if the publicist were dead, for example. However, Your Excellency, the main point is that a publicist should have written widely, researched for years, and indeed the International Law Commission has a special status. It is established by the General Assembly under Article 13 of the United Nations Charter, and indeed has a special role to play in the codification of international law. Your Excellencies, the second precondition laid down for there to be a legal countermeasure was that the measure must be equivalent in some sense or proportionate to the act taken. In this case, in this instance, it was said by the tribunal that when considering what is proportionate, it's essential in disputes between states to consider not only the injuries suffered, in this case the injuries to the Majani economy, but also the principles of international law involved. Your Excellencies, it's Aristan's submission that there are two vital principles of international law involved here, those of diplomatic law and also those of human rights. As my co-agent has argued, the principles of diplomatic law are essential to the effective functioning.
Excuse me, Counsel.
Excuse me, I've run out of time. May I continue?
Let my brother ask the question.
Yes, Your Excellency.
The question I have here is, isn't the question on diplomatic immunity sufficiently uncertain, sufficiently one that is subject to doubt and question, that to take action that literally brings the economy of a country to a standstill internationally is simply not proportionate? In other words, had the act been one, perhaps given the diplomatic immunity's importance, potentially, if that was clear-cut violation, absolutely clear-cut, no question about it, then, but we're dealing here with a question that's before the court, that has been argued by both sides, by counsel, in which we've had memorials filed and heard oral argument as we're doing today. Obviously not a clear-cut issue. But yet you've taken action that has drawn this economy literally to a standstill in terms of its international. You have seized its central bank reserves. It's literally a bankrupt country as a result of what you've done. How can that be proportionate, counsel?
Your Excellency, once again I submit that this court should look to the principles of law involved, but on the facts of the injuries suffered by Majan in this case, I would refer Your Excellencies to the decision of this court in the Nicaragua case. There the court considered sanctions very similar to the present ones implemented by the state of Majan, causing similar damage to the economy. However, this court did not state that those sanctions were not legal countermeasures, that they were violative of Article 2.4 of the United Nations Charter, or that they breached the principle of non-intervention. Indeed, Your Excellencies, on the issue of Article 2.4 of the Charter and of the principle of non-intervention, Aristan does not dispute that those are very important principles of international law. But in order for example, for Article 2.4 to have been breached, there must be a use of force against the political independence of a state. It's Aristan's submission that the use of force contemplated by Article 2.4 is military force, that is made clear by the preamble to the Charter, which refers to the scourge of war. And in any event, Aristan has not sought to undermine the political independence of the state of Majan. It has sought merely to uphold its own rights under international law. And that is also the case with the principle of non-intervention. Even in the most recent declaration on this issue, which was adopted on the 17th of March in 1988, it was stated that a state may not intervene in the domestic affairs of another state in order to subordinate the sovereign rights of that other state. It's Aristan's submission that we are not aiming to subordinate sovereign rights of Majan. We are only aiming to uphold the principles of diplomatic law in this case. Your Excellencies, if I may conclude, that is the real issue in this case, the principle of sovereign equality, of sovereign rights, and a correct balance between those of Majan and Aristan. We have submitted that the ambassador had absolute immunity under the Vienna Convention on Diplomatic Relations, and therefore request the court to declare that he is indeed immune from prosecution. And secondly, we have submitted that there was no international law prohibiting the seizure of the funds in this case, and that in any event, the seizure was taken as a legal countermeasure in response to the trial of the former diplomat. And therefore, we request that this court declare that the funds are not immune from seizure by the Aristani government. That concludes our submissions.
Thank you.
Thank you.
Is there time reserved for rebuttal? Agent for Majan may present the rebuttal. Proceed.
Mr. President, Your Excellencies, I have 2 points I would like to make in reply to the respondent's argument. First, the respondent has suggested that there were certain other remedies provided in the convention that Majan should have exercised. Firstly, there is the persona non grata remedy under Article 9 of the Vienna Convention on Diplomatic Relations. Now, as my co-agent suggested, there was in this situation no need for Majan to issue such a declaration, as the ambassador had been recalled and promptly left the territory of our state. In terms of a waiver, which is also a permissible remedy under the convention, under Article 32 provides that a sending state may waive a diplomat's immunity. Now, Aristan could have offered to waive the ambassador's immunity in this case. There is no onus on Majan to ask for such a waiver. Now, as the ambassador departed from the territory of our state, Majan had assumed that he would be subjected to the criminal jurisdiction of his own state. However, instead, he was merely dismissed from the Foreign Service and went on vacation to the Parrot Islands. It was only at this point, when Majan learned of his presence in the Parrot Islands and of the fact that there was no evidence suggesting that Aristan intended to take any action in its own jurisdiction, that Majan commenced proceedings to extradite the ambassador back to our own territory. Secondly, the respondent has suggested that the ambassador's acts were acts committed in the exercise of his functions as a member of the mission. The applicant contends that in the circumstances of this case, these acts cannot be construed as acts committed in the exercise of his functions as a member of the mission, and that furthermore, the evidence suggests that the respondent would agree with this. Not only did they issue a formal apology for the acts in question and recall the diplomat, but in addition, he was dismissed from the Foreign Service. Now, the dismissal from the Foreign Service would seem to the applicant to suggest that these acts were not acts considered to be within the ambassador's functions as a member of the mission. If there are no further questions, that concludes the applicant's reply.
I just have one short question, because you continue to make the same reference again. The case here is, if your government did not request for the prosecution of the ambassador in his own home country, what would the government of his country do with that? Did he make such a request?
The applicant did not request a waiver in this case. However, it's the applicant's submission that a waiver is designed primarily to permit prosecution in the receiving state while a diplomat still retains his status in that state. It is also the applicant's submission that waiver is an alternative remedy provided under the convention, and that prosecution of a former ambassador for non-official acts is also a permissible remedy under Article 39 of the convention.
Excuse me, Agent. The respondent has argued that even if the trial of the ambassador was proper, they've argued nevertheless that their seizure of those assets was also proper, because it was not necessary that their act be predicated on a violation of international law, only on a likelihood of a violation of international law. And is that the position of your government also? Do you agree with the respondent on that argument?
The applicant does not agree with the respondent's submission on that point. The applicant would suggest that the implications of such a decision would be phenomenal if any time that a nation had a mere belief, reasonable or not, a belief that there had been a violation of international law, if they were permitted to instantly take actions of the nature that the respondent has taken in this case, rather than bringing the dispute before this court or taking it to other forms of arbitration, then the peaceful settlement of disputes would be very much hindered.
One last question. Is it your submission, do you agree with the submission of Aristan that the countermeasure taken by Aristan was or was not proportionate?
The applicant does not agree that the actions taken by Aristan were proportionate. We were merely attempting to assert jurisdiction over a former ambassador, consistently with our obligations, and for various serious crimes, I may add. This is not proportional to the actions which Aristan has taken, which have literally paralyzed the economy of Majan.
Yet you haven't decided to release the ambassador, so it's not proportionate because it's too little?
The applicant does not wish to be coerced into refraining from exercising its valid jurisdiction merely because the respondent happens to be an economically more powerful nation. It's for that reason that we brought the dispute before this court, rather than refraining from prosecuting and giving in to the coercion of the respondent.
So your capacity of endurance has nothing to do with proportionality?
The applicant would submit that the principle here was important enough that the applicant was willing to endure the hardship rather than give in to the respondent's measures.
Thank you.
For Agent, for Aristan, you may proceed.
Your Excellencies, I have 3 points to make in Sarabuttal. Firstly, regarding the remedies available to the receiving state. Indeed, Majan did not request a waiver, did not declare the diplomat persona non grata, and Aristan had given a remedy to the state of Majan. It had withdrawn that diplomat, dismissed him from its foreign service, And further, we submit that there is no evidence that Aristan will not take action and prosecute this renegade diplomat. There is simply no evidence as to that. Secondly, on the issue of what is an act committed in the exercise of a diplomat's functions, Aristan did not submit that drug smuggling is an official function, is an official act, but that it was committed during the exercise of that diplomat's functions, and therefore he should be accorded absolute immunity.
During the exercise, not in the exercise.
In the exercise of his functions. I stand corrected by the bench, Mr. President. Finally, on the issue of countermeasures, which was raised by the bench, Aristan submits that indeed the countermeasure taken was proportionate. Firstly, because, as this court said in the Nicaragua case, they were not prepared to extend the principle of non-intervention or the principle of non-use of force to sanctions taken which were very similar to the sanctions in the present case. And secondly, because of the vital principles of international law involved, those of diplomatic law and the possible abuse of Ambassador Kitaro's right to a fair trial. That concludes our submissions.
The International Court of Justice is now adjourned. After deliberation, the bench will return to reward the Jessup government.
Thank you, Mr. Chairman. Indeed, the court is delighted, indeed, to judge this final round. And the president has made a very impressive presentation. And we are all excited. And as I should tell you here, we do have a unanimous decision, which is also very important. As to the best oralist, which is our consensus and our agreement, that Lisa Johnson is the best oralist. The Jessup Cup World Champion is Team 144, which is the University of British Columbia. This is for the keep, of course. You have to preserve it for the next group
Beware
of
the
winners.
weight of responsibility.
Don't let them get away. This is the team this is the trophy they keep for permanently.
One more.
Lisa, you like to pick?
This for the keep.
Present the other.
Yes. The run-up for this year, again, I would say that we were very much impressed in the presentation made here. So the run-up is the team 116. Is the University of Melbourne, in Australia. If you run out of it.
Yes.
Would you like to make some more
Yeah.
comments? Okay, just announce that.
Now, I will ask my brethren to give their comments regarding the excellent performance by both teams.
Thank you, Mr. Chairman. Over the years since this Jessup has been going on, it's always a custom to make a brief comment in terms of the impression of the judges. As to what I think the subject matter this year is a very important and historic one. The question of diplomatic immunities is one of the central aspects of international law. As a matter of fact, the very first case dealing with the diplomatic immunity was recorded in 1568. And this was in connection to one Don Bernardino de Mendoza from Spain. He was the ambassador of Spain who was accredited to the Queen of London, Queen Elizabeth I of London. And it happened that he was accused of plotting against the sovereign, and therefore was charged in Great Britain. A commission which was arranged by Queen Elizabeth I was charged to look into the affairs of the ambassador, who was then, of course, plotting. And the reason for his plotting was the fact that Spain was in some alliance with Scotland at the time, and was in sympathy with the Queen of Scots, and who was then Mary Stout of the Scots. And it was decided that because of his diplomatic immunity, due to the accreditation of Ambassador Mendoza, that he would be asked to vacate England and go back to Spain. In order to be sure that he leaves the country, he was placed in the captain of the English vessel by the name of the captain Hawkins. And Hawkins was able to deport him back to Spain and discharge him in a port called Calais. That was the first case in diplomatic immunity, and it was recorded by a great scholar who was the Regius Professor of All Souls College in Oxford. His name is Alberino Gentile. Gentile is recorded a classic of international law, which was edited by James Scott. That became a very important case. The case that's very close to it was the case of the ambassador of Scots to Queen Elizabeth of England. His name is Ambassador Leslie, John Leslie. John Leslie was the Bishop of Ross and became the advisor to Queen Mary Stout. Queen Mary Stout, of course, in 1568, there was commotion in Scotland, and she did seek refuge in the reign of Queen Elizabeth I. During the time she was in England, she was charged for plotting against the state, and therefore Leslie Brown claimed that he cannot be tried in England because he is the ambassador accredited to the court of the Queen of England. Again, a commission was summoned in England to look into the matter, and the commission of jurists that was formed in 1511 and stayed till 1568. That commission stayed till 1584. That commission looked into the case and decided that John Leslie, even though was accredited to England, but then the Queen of Scots was no longer Queen of Scots because the people of Scots no longer wanted her to be the queen.
in which case there was need for the unification of the provinces, which of course brought Scotland into the reign of England to become one single nation. So in this regard, the Queen of Scots has no jurisdiction because she was no longer a queen. So Leslie Brown, his case was defeated. And he was, of course, sent to the Tower of London, and later he was released. Then, of course, he died a couple of years later. These are two important cases that dealt with diplomatic immunity. Mr. Ambassador Leslie was himself a lawyer because he obtained a degree from France, and he actually argued strongly that as an ambassador he cannot be tried. And of course it was decided because of the nature of Scotland he should be tried because he was no longer ambassador at the time the Queen herself, Queen of Scots, was no longer Queen of Scots. So they have already yielded to the Queen of England, Queen Elizabeth. So in this regard, again, you see a similarity to the issue that you decided here. So those two cases, which were recorded by Alberino Gentili, are the two most important cases because they were also commented by Hugo Gracious, who was another jurist of the time, who had written on One Piece, as you may know, and also recorded by Zuki, another professor of Regis at Oxford, who also recorded at the time. And all these were recorded as a classic of international law, which of course gives precedent in terms of the need for diplomatic immunity and of course the continuity of that institution in order to preserve the right of ambassadors who are representing sovereign nations. Thank you very much, Mr. Chairman.
I ask my brother Edward, Judge Edward.
It was a pleasure to hear the arguments that were presented before us today and to read the memorials that both teams prepared long ago that have been with them all through this competition. Well, they've had the opportunity of refining their arguments orally. Their memorials carried with them all the time. And so the initial preparation that was put into this competition was very important to why these two teams were before us today. They had to perform well, both written and in oral. You have not seen the written memorials. We've had the pleasure of reading them. One of the interesting features of this problem this year is that while it combines a subject that is very ancient in international law with regard to diplomatic immunity, it also deals with the question of monetary affairs and regional organizations. That's relatively recent developments. In fact, the parallel to this organization almost does not exist. We have a regional organization of some 60 members that have essentially surrendered their role in monetary affairs to this regional organization. The only real parallel we have is the French West African states with the CFA franc. That is really the only parallel we have, and that's of course a much smaller organization. But as we think about the potential that is being talked about in the European community of centralizing monetary institutions, we can realize that some of the ideas that are embedded in this problem might be things that some 25 years from now will not seem so strange and unique. At the same time, the international law has had to wrestle with the development of its rules with respect to the assets held by regional organizations, for example. And indeed, the President of this court has served as a rapporteur of the International Law Commission on some of the subjects that dealt with today. And one of the questions is, are we limited to essentially treaty development in a subject that is relatively new, okay? Or is there a role for international judicial institutions to play in the development of international law with respect to a subject like this? So we were dealing today with some issues with respect to law development as well as the specific questions of who should prevail with respect to perhaps what might be concerned as, quote, pre-existing rules, if we could identify.
I thank my brethren for the most interesting comments, and I would like to congratulate both teams for their excellent performance.